Hello, my name is Christie Arkovich, and we are in Tampa Bay. We're attorneys that work a great deal in student loans, foreclosure defense, and bankruptcy. I wanted to do a video, and thank you for all the wonderful compliments about our videos and how much they've really helped people in figuring out their student loans. I'm really glad that this has been a good resource for folks. But I want to talk today about the double consolidation issue. Is it dead? We actually don't know. Here's some of the issues that are at play. First of all, what is double consolidation? If you have a Parent Plus loan, if you want to go on an income-driven plan, the only plan that your loans are eligible for is called ICR, Income Contingent Repayment. It comes in usually a few $100s higher than the new SAVE does. I won't get into all the details. You can watch some earlier videos if you want to know how the computations affect that. But just know ICR is usually not the best plan to be on for income-driven. SAVE is a lot less expensive. So how do you get on SAVE if you have a Parent Plus loan? Well, Parent Plus loans, according to Congress, are only eligible for income contingent repayment, so you can't. However, there's been a software glitch. Over the last few years, there's been an issue where if you do a double consolidation to where the second consolidation does not have any basically tags that shows it has a Parent Plus loan within the consolidation, that the loans become eligible for anything, for SAVE, for IBR, or what have you. And that's called the double consolidation. We have some videos about that as well. So interestingly, there was in July of 2023, there was a new rule that was passed by the Department of Education. And I believe at the time that it provides a safe harbor for people who want to do this double consolidation. There's some text before the rule that talks about all the folks who have consolidated over the past year or two to take advantage of the IDR recount. They maybe haven't known to keep their Parent Plus loans separate, and they've rolled them together, and they've then applied for SAVE. And so they don't want to have those folks not be eligible for SAVE. So that's the context of this ruling. And so the ruling says we added 685.209 𝗖ः to provide that a direct consolidation loan made on or after July 1 of 2025 that repaid a Parent Plus loan or repaid a consolidation loan that at any point paid off a Parent Plus loan, so any loan types that you used to have a Parent Plus loan, is not eligible for any IDR plan except ICR. So it says after July 1 of 2025. So that tells me the opposite is true, which means that if you do this before July 1 of 2025, that your loans potentially could fit into SAVE or IBR, even though Congress has said that ICR is the only income-driven plan available for those with Parent Plus loans. Okay, so I advocate that this is a safe harbor, that this is a time period. We have a little bit of time left that people can take advantage of this glitch, this software glitch, and try to do that. Nevertheless, I encourage folks to do it when it's no harm, no foul. If you do a consolidation of your Parent Plus loans to be eligible for ICR, and then you do it again, and there's a certain way you have to do it, so be very careful on how you do that. If you do it again, you may be eligible for SAVE. There's no harm if you're not eligible for SAVE. You just simply go back to ICR. You would have been in ICR anyway, no big deal. Where I have not advocated trying to take this risk is if you have a big pile of your own loans that are not Parent Plus, you wrap them together with Parent Plus, and then you taint all of them. So that if you're wrong, if this is not a safe harbor, then all of your loans are only going to be for ICR. So you've effectively shot yourself in the foot. When you have a harm that could come from taking this chance, then I don't advocate for it. Or I let you make your own decision, of course. We try to stress in our strategy sessions the positives of doing something and the negatives. So another negative, let's say you're consolidating loans and you have a lot of interest that has accrued but has not yet been capitalized. Okay, when you consolidate a loan, all that accrued interest is going to become principal and bear its own interest. So there are times that you want to maybe keep that separate so that the interest does not capitalize. So that's another issue there. That's another reason why you might not want to do a double consolidation in case you don't ultimately end up on SAVE. All right, so we know about that safe harbor and so forth. About a week or two ago, there was a new wrinkle in this, and the new wrinkle is the Parent Plus Consolidation Indicator. It's new text that appears within your National Student Loan Database Report, the NSLDS report. And it says Parent Plus Consolidation Indicator. So why is it in there? It was just put in here in August of 2023. To our knowledge, it didn't exist previously. So you have a rule that says, I believe, that they're going to limit people to ICR who do this double consolidation only if it's done after July 1 of 2025. And then you have this new indicator on the National Student Loan Database report that now says whatever. I mean, what's the indicator there for? It's to identify if a consolidation loan has Parent Plus loans in it. So the real question is, with this indicator, when does it take effect? Why was it written into the software now? All right. So generally, I'm of the school of thought that when you do something, you're doing it for a reason. So you have the rule and all the requirements that it took to make that rule, and you have the software indicator and all the requirements and money and time that it took to put the indicator in there. So they were both intentionally done for some reason. So if you're going to have the indicator relied upon now, starting right now, which means that anyone who applies for SAVE, if they have a consolidation loan that contains a Parent Plus loan, they would not be eligible for SAVE. If they intend on that, then why have the rule? Why have the rule if you have the indicator? And so how do you have a world that both things exist at the same time? One possible answer is the indicator was put in there to be used later or to be used upon a certain set of circumstances. So for the rule to still have meaning, that would mean that they wouldn't care if a consolidation includes a Parent Plus loan, as long as it was done, or at least started, before July 1 of 2025, right? I mean, that makes sense. So we just don't know. We don't know when the indicator takes effect. If it takes effect immediately, if it's going to be anyone who applies for SAVE now with a Parent Plus loan, will they no longer be considered for that? What happens if you were on repay and you're automatically moved over to SAVE? Does the software do an evaluation of whether you were eligible for repay to begin with, or does it just compute your payment under SAVE? I doubt it goes backwards. I really doubt that. But I think the only way to give meaning to both the rule and the indicator is to think about why they were both created. And is there a possibility that that indicator might not take effect until July 1 of 2025 to be able to easily be the mechanism to implement that change? July 1 of 2025, anyone who does a consolidation that contains a Parent Plus loan is only eligible for ICR. Here's the indicator that will automatically trigger that event, and SAVE will no longer be a possibility. That makes total sense to me. That means we might still have the safe harbor. On the other hand, I believe there's a lot of attorneys out there that are advocating, or probably will be advocating, that the double consolidation window is dead, that the indicator is now in the software and we can't do that any longer. We really don't know. We have no way of knowing. So as an advocate, here's what I would suggest. I would take the shot if it was an asymmetrical bet, which means if you don't have much to lose, then why not take the shot? So in other words, if the difference between the ICR payment and the SAVE payment is so much to where you can't make one, but you can easily make the other, if there's no harm, then why not do it? And what would be the harm? Well, the harm would be is if you have a pile of your own loans and you combine them to try to do this. Well, maybe you don't want to do that. Maybe you don't want to taint your own loans. But if all of your loans are Parent Plus anyway, then why not take that shot? You're going to be an ICR anyway if it doesn't work. So why not try to get into SAVE? Another way is you could take another small loan out. Well, if the new small loan was a class you wanted to do anyway, and it was less than $1,000 or something insignificant, and the pile of loans that you have that potentially could benefit from SAVE is huge, then that's an asymmetrical bet. Yes, you're taking a class. Yes, you're taking a new loan. It's very, very small. You kind of wanted to do it anyway. It's something you've always been interested in. It's not that inconvenient. It didn't make you quit your job to take the class, nothing like that. Then you might want to take that chance. But by no means should you take the chance if it's going to cause you a lot of harm if it doesn't work. So I would look at your accrued interest to see if it's going to be capitalized and whether there's a way to avoid that. I would look at not tainting your own loans if they're significant with this double consolidation to try to get into save. But if you have nothing to lose, then maybe still take that chance, because the rule was written for a reason. And there's a lot of work that goes into a Department of Ed rule. They don't just make them willy-nilly. So why have that rule if they didn't mean for that safe harbor to exist? Again, it says we added this provision to provide that a direct consolidation loan made on or after July 1 of 2025 that repaid a Parent Plus loan or a consolidation loan that had a Parent Plus loan that's not eligible for IDR except for any IDR plan except ICR. So it's after July 1. They're basically saying that you're only going to be eligible for ICR. Why have that rule if there wasn't? Why have that rule implemented July 1 of 2025 if you didn't intend for the ability to do a double consolidation up until that time? Maybe you have two different work groups. Maybe you have a work group that's doing the software implementation for the indicator. Maybe you have a work group that's doing the rule. Maybe they don't talk. And maybe they're just, maybe the indicator goes into effect right now. And anybody who tries to go into save that has a Parent Plus loan won't get in. I'm hoping that that's not what it means. I'm hoping that it will be triggered on July 1 of 2025 to where that double consolidation window is forever completely closed. Could be closed now, but I'm hoping that it may still be open until July of 2025. You have to make your own decision. Feel free to reach out to us if you'd like some assistance in going through that again, going through the decision process to see whether it's the best thing for you or if it's just taking too much of a chance. Our email is info@ChristieArkovich.com. Our office number is 813-258-2808. And please subscribe to our videos. It helps us get the word out. We have a lot of folks who are very complimentary of the information that we provide, and we try to do so from an advocacy point of view. We're not regurgitating what we see on studentaid.gov. Our eyes would glaze over, as I'm sure yours would as well. And hopefully these videos are such that you can learn something, you can improve your life by using the programs legitimately, lawfully to get rid of your student loan debt. So again, it's Christie Arkovich, and I hope y'all have a wonderful day.